We are on the record.
Hi there, good morning. This is D530134, Ryan Geraldo versus Andrea Gutierrez. Counsel, your appearance for the plaintiff, please.
This is Michael McLaughlin from ESO and Associates on behalf of Ryan Geraldo, phone number 12820.
Thank you. And Ms. Gutierrez, I can see that you're there. I don't see you by video. Can you appear? There you go. Thank you. All right, good morning. So this is on, the court set a status check following our last hearing. The court directed that the plaintiff submit to a follow-up drug test in light of representations he made regarding the results of his last drug test. My understanding, he is not going to be present today. Is that right, counsel?
Yes, Your Honor. If need be, he said he could try to appear by phone, but he's on site at a construction site, and we probably wouldn't be able to hear him over the machinery.
Okay. So at the last hearing, as I stated, he was directed to submit to another test at ATI, hair and urine, confirmed with him that he would be able to submit by 5 p.m. that date, and he did not. I believe the department received a call from ATI the following day indicating that he appeared on the 14th, so the day after, and they were unable to have him submit to the test because it was later than the court had given him permission to. So is there anything specific, counsel, that you want to make representations regarding on behalf of your client?
Well, Your Honor, I do know that I do have test results that he provided me from July 14th at 2:29 p.m.
Okay.
Urine toxology.
Okay, not hair.
No.
Okay. Why don't you tell me about those?
The urine toxology came back negative for everything except for BUP, which showed positive.
BUP?
And I apologize that yes, that's the abbreviation it gives for whatever that particular category is.
Give me 1 second.
Sure.
Don't know what that is, and it wasn't on his last test.
And Your Honor, since I'm unfamiliar with this, if you'll indulge me, I'm just looking now in my files to see if there's anything else that he provided. And I could, I'm assuming
I see what it is.
the court didn't get copies of it.
No.
Oh, I apologize for that.
So interesting. Ms. Gutierrez, this is important for you to understand. The court's not going to litigate this case for you. It's not appropriate for me to. My interest in obtaining drug test results for the plaintiff was an interest that extended as far as necessary to determine if a referral needed to be made to Child Protective Services. So you understand where the court is on this, Mr. McLaughlin.
Yes, Your Honor.
Court had already made findings that the defendant was an unsafe primary caregiver. These were findings that existed that predated me. That the defendant was an unsafe primary caregiver. The plaintiff was adamant in this, but there was behaviors by the plaintiff that were very concerning to the court, and indicated to this court, based upon my years of experience doing child abuse and neglect for the Department of Family Services and doing domestic violence cases for the 8th Judicial District, that there was a drug problem. And we have a child that is identified by the plaintiff himself as a special needs child and requiring specific attention. And because of those concerns, the court directed that he submit to a drug test so I could ascertain whether there was a risk to the child. The drug test that he submitted to, when the court directed that he submit to the test, when he had no indication that that was going to be requested by the court, was positive in both hair and urine at levels that suggested there was repeated and ongoing use. When he was confronted with that, his response was that it was consistent with medication that he takes. I asked him to provide proof of that from his physician. In other words, submit those prescriptions to the court. When he did not, I set the matter for a hearing. When I asked him under oath to be more specific about the medication that he is prescribed, he was evasive and ultimately said to the court that he has been on a medication intended to treat chronic opioid addiction, that he is to refrain from use of opioids while he is on this medication, which is contrary to the results received from his drug test, which showed, in fact, frequent and ongoing opioid use, and told the court that he, to get this drug to treat his opioid addiction, must submit to drug tests by his treating physician, and that they have never come back positive. This is his sworn testimony. I found that hard to believe. I asked him to explain then this test, and he said it was a slip, meaning his use of the opioids. I found it very hard and continue to find it very hard to believe that out of the 5 years 4 or 5 years he alleged that he's been treated for opioid addiction and has tested negative for his treating physician, we happen to get the one slip that he admitted to and caught that on our test. Which is why I asked him to submit to another test, and now what he is testing positive for is this drug, bupropion, which looks to be the drug that, in fact, treats his opioid addiction. So I continue to be concerned about his drug use. I can tell you that at the last proceeding, he was disoriented. His speech was somewhat incoherent and slurred. I'm not sure what to do. I continue to have concerns. I don't have any reason to believe that the defendant is any more appropriate to care for this child than he is. It's unfortunate that he's not here today. It's unfortunate that he didn't submit to the drug test when I asked him to. It's unfortunate he didn't provide a statement from his doctor or any other information that's been asked of him. It's not that the court isn't giving him opportunities. But again, this isn't my case, and all I can do is make the appropriate referral based on the information that I have. If there's anything you care to say on behalf of your client, you're welcome to. If there's nothing you need to say, I respect that as well. These are unusual proceedings.
Well, and Your Honor, if I may, and they are unusual, but I understand the court's concern. I'm not sure if another attorney was handling this on behalf of my client prior to, but if it would please the court and put the court's mind at ease, I would ask for a little bit of time to see if I can get the documentation from plaintiff's doctors, finding out that he is on this medication, that he will stay on this medication, how long he's been on this medication, if he's ever tested positive in the past for these doctors for any opiate use along with this, how often a positive may have come up. Understandable that if he's on this medication, he has had opioid problems in the past, and I'm sure that part of the court's concern is that he appears to not be being forthright with the court on his recovery. And I would like the opportunity to try to rectify that, at least as far as putting the court's mind at ease that he is being straightforward and honest with the court about his recovery and what his use is.
Again, there's nothing pending before the court. The underlying issue that brought this matter before the court was the defendant's motion to enforce her visitation rights. He filed a counter motion. Those issues have been resolved. I will let you know, I'll let Ms. Gultierrez know, I'm going to go ahead and make the referral that I think I'm mandated to make based upon all the information that I have. Certainly there's going to be an opportunity for him to still respond to any concerns. If my concerns are unfounded, then the appropriate investigative agency is going to find that out for themselves. I don't know if his doctor knows about his positive drug test, but I don't think it's my place to involve myself in that. That's not the court's role. It's the role of an investigative agency who's charged with the responsibility of protecting children. So again, I'll make that referral, and I'll let them do what they need to do in the course of ensuring this child's safety. He's 14 years old, but for the fact that he has special needs, I might not have concerns, but he is, and so I'll let them decide how to handle it, okay?
Your Honor, may I say something?
Absolutely, Ms. Gultierrez.
Thank you. So my son is 14 now. His needs of prior, before aren't the same as they are now. He's grown out of his issues. The dad and, his wife took care of, all the doctor's appointments. I never said that they didn't. But he doesn't have this problem anymore. And he hasn't been to the doctor for it recently. But my son does specify to me every time he comes and sees me for the 8 hours on the one day that I get him, which is a weekend, that, he doesn't have any more issues. So I just want to make that known. And I'm not asking for full custody. I'm not trying to take him away. I just want my son more than 8 hours.
Well, but that's not what's before the court today. I mean, that issue was resolved. There's no motion pending before the court. You can file something else if you want the court to consider those issues. I've moved past that. I had concerns about the plaintiff. That's what I've moved on to address. Okay. So again, it's not for me anymore to look into. I needed to satisfy myself whether there was any safety issues, and I have ongoing concerns, and somebody else has to address them now.
Understandable. Thank you.
Okay. Thank you. Anything else, Mr. McLaughlin?
No, Your Honor.
Okay. Thank you. There's obviously no order necessary as a result of today's hearing. The case will be closed. As far as this court is concerned, that doesn't prevent you, Ms. Gultierrez, from filing further proceedings. It just means with respect to the motion that had brought the case or reopened the case, it's closed now. Thank you all.
Thank you. In respect of you, I didn't file anything because you told us not to at the time. So I am glad you gave me the clear to do so.
You're welcome.
Thank you.
Okay, thank you.
Thank you, Your Honor.